Hi, I'm Michelle Malkin for Conservative Review. Are you ready for my Beyond the Cable TV Soundbites briefing for the week? Monday, April 18th is a big day for American sovereignty and the rule of law at the U.S. Supreme Court. The justices are hearing oral arguments in U.S. versus Texas. That's the so-called Obama executive amnesty case. Here's what the superficial, lazy, and uninformed cable TV pundits won't tell you. This case is about much more than just illegal alien amnesty. At stake are these fundamental questions. Are we a constitutional republic or a banana republic? Do we have a system of checks and balances like they used to teach us about in grade school, or do we have an imperial executive branch and an out-of-control politicized high court? Do we have a president in the White House or an all-powerful Caesar? By a wave of his hand, President Obama and his Department of Homeland Security minions issued blanket deportation waivers and work authorization permits in 2012 to 1.2 million young illegal immigrants, the Dreamers, and 4.3 million parents of an even broader class of illegal aliens in 2014. There was no congressional debate about the impact on American citizens, American taxpayers, and American workers. There was no public comment period as required by the Federal Administrative Procedures Act. There was nothing. A group of federal immigration and customs enforcement agents, along with the state of Mississippi, challenged the original executive amnesty called DACA, as did Arizona's Sheriff Joe Arpaio. Both of those lawsuits were dismissed over the highly abused and politicized court mechanism called standing. Basically, plaintiffs must demonstrate an injury resulting from the challenged action in order for a lawsuit to proceed. But over the years, the judiciary has invented standing requirements out of whole cloth and issued contradictory and inconsistently applied standards at whim. Despite the very real impact that granting amnesty to millions of illegal aliens, and showering them with work permits and driver's licenses and in-state college tuition and access to education and health care has on every American taxpayer and legal resident, the Fifth Circuit rejected those initial lawsuits based on standing. On a separate front, Texas and 25 other states mounted their own challenge to Obama's second wave of executive amnesties extended to the parents of the young illegal alien dreamers. That was known as DAPA. The states argued that the program violated the constitutional Take Care Clause, requiring the president to take care that the laws of the land are faithfully executed. Texas and their co-plaintiffs also argued that DAPA violated federal public notice and comment regulations, and that it exceeded the Homeland Security Department's authority. U.S. District Court Judge Andrew Hannon in Texas ruled in favor of the states based on the administrative law challenge, and he put DAPA on ice. Well, last fall, by a 2-to-1 decision, a Fifth Circuit majority agreed with Hannon and determined that the state's case was likely to succeed on its merits. They called Judge Hannon's ruling impressive and thorough. Judge Jerry Smith wrote, "At its core, this case is about the Department of Homeland Security Secretary's decision to change the immigration classification of millions of illegal aliens on a class-wide basis. Under that abandoned old piece of paper known as the U.S. Constitution, it's Congress that defines the classes of immigrants eligible to work in the United States, and it's the executive branch that has the authority to determine the individual immigrants within those classes who are authorized to work." Well, Obama and his Department of Homeland Security flipped that around and usurped the authority to allow any alien, legally or illegally in the country, to work unless Congress explicitly prohibits it. As John Miano, my co-author of the book Sold Out, and a pro-U.S. sovereignty lawyer who is representing other American workers who are challenging executive expansions of immigration programs, points out, the implications of Obama usurping carte blanche powers to override Congress's plenary power over immigration are stunningly disastrous. Here's another thing. This case shouldn't even be before the High Court today. Sore loser Obama and his open borders lawyers saw the writing on the wall after the lower court's stinging rebukes against his executive immigration orders. Then Team Obama ran to the Supremes to intervene instead of allowing U.S. versus Texas to proceed to a full trial on the merits in the lower courts. Obama and his liberal judges have worked hand in hand to achieve what my conservative review colleague Daniel Horowitz calls stolen sovereignty. What we need are representatives on Capitol Hill and in the White House who have the smarts and the guts to reclaim our sovereignty instead of funding and facilitating the treacherous thieves.